Hello, everybody. Welcome to Introduction to Maxims of Law, a Smart Candy production brought to you by Music, Media, and Ministries. The first thing we're going to do is define the word law. I was looking for a definition for the word law, and what I came across instead was several commentaries that said there's really not a cut and dry definition for the word law. And I believe that's the reason for that is because it's an acronym. It's an acronym that it's an old acronym for land, air, and water, and we've been using it as the word law because it just makes it refers to a body of rules or that sort of thing. But I believe that what it actually refers to, I'm going to talk about on the next screen, is the jurisdictions of land, air, and water. And there are several other jurisdictions as well, but these are the main ones. And the word law is easy to remember. The acronym for law is easy to remember, and I believe that's why they adopted it. So the reason that it's important to define the word law is because we use legal and lawful to mean similar things. However, they are very different. So the 1893 Dictionary of Arts and Sciences defines legal as the undoing of God's law. Now, the fact that it was actually printed and put out there um, with that definition should tell you something. The legal profession is actually the fussing over the statutes and the different rules and this, that, and the other, where lawful is the actual body of rules that apply. The definition of lawful is being in harmony with the law, such as a lawful judgment or a lawful purpose to be constituted, authorized, or established by law. And so we refer to the different maxims as either legal maxims, depending on how they're termed, or maxims of law. The maxims of law come from a much older text. They come from common law, natural law, the Bible, the older references and the older instructions for the court procedures. Whereas legal maxims are come specifically from the courts of chancery or courts of commerce or specific jurisdictions. And so the legal maxims that we hear the most often are, you know, the most common ones that are used. And I've included some of those here, but I've also included some lawful or some maxims of law that are derived from the older texts. And you can, if you really think about the purpose of what's being spoken of in using these terms, you can feel a big difference. The word legal and the description of the legal profession, it brings about anxiety and worry and uh, like nitpicking at the details and that sort of thing, because that's exactly what it is. Attorneys are given in school, they're given what's called a devil's handbook. The devil's handbook is basically a guide for procedural law and how to extend the cases that they take and that sort of thing. And so the reason I think that it's really, really relevant is because they use the same word to denote that handbook as they used for the enemy in the Bible. And now we have to remember that when Jesus was around, there was no Bible. What he was teaching and preaching at the temple was the law, the Torah. And so he was a teacher of the law, and he wasn't preaching, he wasn't, proselytizing uh, a spiritual experience. He was sharing education about the actual law. So, um, you know, law is the English word for it. Back then they called it the Torah. So the land, air, and water jurisdiction, there's another graphic in the previous video that I did that shows how the air is the jurisdiction of natural law. This term may sound familiar, nature and nature's law. And that's the God of the Christian Bible, the one God, the one true God. And then you have the land jurisdiction, which is also governed under the laws of God. The water jurisdiction, which is actually governed under the laws of God, and they do absolutely acknowledge the Torah within those laws. However, that's the jurisdiction of commerce and contracts, and that's where the devilry and the barratry is really, really prominent because it's easy for them to get people bound up into contracts and that sort of thing. And so we're going to go over we're going to go over the maxims because we're studying how to overcome those uh, legal disabilities that are imposed upon us. So in the phrase maxim of law, a very key term is the word of. The word of, just like every other legal term, it's a tiny little detail. It sounds, like it should make plenty of sense, but the definition of it is, if you really look at it, what it denotes is that it is the maxim is the item being referred to, and of denotes the relation or association with the maxim. So a maxim of law is not the law. It's a principle of law. And that's the reason that they say that there is not really a definition for the law. So the first maxim we're going to go over is a workman is worthy of his hire. So the legal version of that law, maxim of law, is it's against equity for freemen not to have the free disposal of their property. So the legal maxim it says basically the same thing, but it includes some terms that's not included in the maxim or the lawful version of that maxim. So equity is a term that is used in higher forms of law. It's referred to in contract and commerce, but it's actually a higher jurisdiction. It's actually more of the land and air jurisdictions. It's a concept that is derived from the Bible. And so we've got some Bible references here that show the working of this maxim in the scriptures. It says, "You shall not steal, do not defraud or rob your neighbor, do not hold back the wages of a hired worker overnight." And then in Matthew 10, when he was given the apostles or the disciples instructions for carrying the good news across the world, it says, "Do not carry a traveler's bag with a change of clothes and sandals or even a walking stick. Don't hesitate to accept hospitality because those who work deserve to be fed." And then in Luke, he says basically the same thing again. Don't move around from home to home. Stay in one place, eating and drinking what they provide, and don't hesitate to accept hospitality because those who work deserve their pay. And those are instructions to the leaders and the disciples, the ones who are bringing the good news. And they're also a reference back to the Old Testament, Exodus, Leviticus, Old Testament maxims that, and the Ten Commandments that they gave, that was, one thing that they used it for was a way for them to govern their own lives, but they also used the commandments as a guide for how to adjudicate issues that were brought before the judges. And there's a whole entire set of books that is dedicated to the works of the judges in the Old Testament. So these were actually these were instructions to the judges as well as they were instructions to the laymen, and their culture was different. So whenever they traveled to the temple, to the synagogue every year, they weren't just traveling to go have a party and have a feast with or do the census. They actually, when they spent time at the tabernacle, the purpose of being there was to read the law. They read the Torah over and over again. That way, they knew the rules. They knew what was expected of them. The judges and the priests knew how to govern society. They had a set of instructions. That's what they were for, and that's the reference to maxim is the set of instructions or the guidelines for operation of the law. And the law, I believe, denotes those jurisdictions. So I just wanted to clarify that. Okay, so the maxim that all are equal under the law is correlated in a legal maxim by something that sounds similar to "no one is above the law," or "commerce in the law of nations ought to be common and not to be converted into a monopoly in the private gain of a few." So the legal maxim and the maxim of law sound very similar, once again, but it uses a little bit different words. So I don't want to belabor that point, but okay, so let's go over the Bible references. So if there's serious injury, you are to take life for life, eye for eye, tooth for tooth, hand for hand, foot for foot, burn for burn, wound for wound, bruise for bruise. So that was a reference to the equality, so that the people who are being punished are not put on a higher or lower state than the people who they committed the crime against. And then in Leviticus, it says that killeth a man shall surely be put to death, and if he kills a beast, he'll make it good. He'll replace it. If he causes a blemish in his neighbor, whatever he did, it'll be done to him. So, if he breaks his foot, then they'll break his foot. Breach for breach, and it goes through the whole thing again. And once again, it says that if he kills somebody, he shall be put to death. And that just shows the equality that goes along with the maxims of law and the legal maxims. So there's also the you shall not be partial in judgment. This is the instructions to the judges. You shall not be partial in judgment. You shall hear the small and the great alike. You shall not be intimidated by anyone, for judgment is God's. And the case that is too hard for you, bring it to me. And this was, I believe, this was the instruction of Solomon. And your eye shall not pity, and it shall be life for life, eye for eye. These were the instructions how they were to adjudicate these cases. I need to probably research and make sure that it was Solomon before I go telling people that Solomon wrote the laws in Deuteronomy. If I'm wrong, please correct me. I'd like to know the truth. Thank you. And then there's this one. This one is it speaks to from the New Testament. When the Pharisees heard that Jesus had silenced the Sadducees, they themselves gathered together, and one of them, an expert in the law, tested him with a question about the greatest law. And he says, love your God with all your heart, with all your soul, and all your mind. And this is the first and the greatest commandment. And the second is like it, putting it on equal footing. Love your neighbor as yourself. It's just as important as loving God. So all the law and the prophets hang on these two commandments. And these are the most prevalent, most commonly heard maxims in court cases and that sort of thing. And so in dealing with contracts, this is a maxim that you can expect to be able to enforce because it's so commonly, everybody knows about it. It's not something, obscure or in some old book that you have to dig for it or anything. Every judge in every court, every attorney that you talk to is aware of this maxim. They know what it means. And so if there's discrimination on for any reason, you can use this, and it's actually come in pretty handy, especially in the consumer credit circles, because and I heard a really interesting take on it was that a man, applied for credit, and he had a 450 credit score, and he was denied. And he asked them, he said, if I had an 850 credit score, would you have given me the loan? And they said yes. And so he was able to take that response and submit, show that was discrimination, and he wound up getting the account that he was wanting, because all are equal under the law. So this slide here has two different concepts on it, but the bottom scripture is, he that doeth wrong shall receive for the wrong which he's done, and there is no respect of persons. But this one here, Luke 10:17, the 72 returned with joy, saying, Lord, even the demons are subject to us through your name. So we've got the land jurisdiction, we have the air jurisdiction, which is the highest jurisdiction, and then the jurisdiction of the land and soil, and that's us. Our bodies are basically real estate, or we're physical beings. And there's the water jurisdiction, which is commerce and international law, or contracts, policies, commercial codes. All of those things are under the water jurisdiction. And so the 72 were excited to come back and report that when they had, encountered demons before, they behaved a certain way, but when they came with the authority of Jesus Christ, that they got a completely different response from the demons. And that speaks to jurisdiction, because what they said is the demons are subject to us through your name. So they were under that jurisdiction, and that's where that fits at. So that if that helps you to understand the concept of jurisdiction and how it works, then yay. So in commerce, truth is sovereign. Exodus 20:16 says, thou shalt not bear false witness. And then, for great is his loving devotion toward us, and the faithfulness of the Lord endures forever. Speaks to the truth of the matter. And then in John, he talks about you will know the truth, and the truth will make you free. And then we can do nothing against the truth, but only for the truth. And the legal maxim is to lie is to go against the mind. And there's also an Oriental proverb that says, of all that is good, sublimity is supreme. And sublimity is the um, is adherence to higher ideals and higher concepts, which would be the truth. And then truth as a valid statement of reality is sovereign in commerce, equity, admiralty, lex mercatoria, and public policy. Truth is always superior to fiction. When you say truth is superior to fiction, you can also look at jurisdiction the same exact way. The true jurisdiction is the law of nature and nature's God as it relates to the soil, human beings, our bodies, our physical bodies, and our the things that you can touch, hear, see, smell, taste. All right. Truth is expressed in the form of an affidavit. An affidavit is a written declaration or statement that's sworn or affirmed before a person who has authority to administer an oath. So it's a sworn statement. And so these scriptural references are very relevant. If a person swears, speaking thoughtlessly with his lips to do evil or to do good, whatever it is that that man may pronounce by an oath, and he is unaware of it, when he realizes it, then he shall be guilty in any of these matters. And so, the rest of them speak to the seriousness of the oath as well. You shall not steal or deal falsely or lie to one another, and you shall not swear by my name falsely, nor shall you profane the name of your God, or to make it profane doesn't mean to say GD. It actually means to make it of no effect, to make it worthless or to diminish the authority of the name Yahweh. It says, I am the Lord, and that word translates to Elohim. And it says, you shall not cheat your neighbor or rob him. If a man vow a vow unto the Elohim, or swear an oath to bind his soul with a bond, he shall not break his word, and he shall do according to all that proceedeth out of his mouth. So now we use written documents to do the same thing. When you swear an oath, you're bound to it, and it holds up in court as the truth. And again, you've heard it said that those of old, you shall not swear falsely, but you shall perform to the Lord what you have sworn. And then James, this is a little different. It says, but above all things, my brethren, swear not, neither by heaven, neither by earth, or any other oath, but let your yea be yea, and your nay be nay, lest ye be brought under condemnation. And so one way that people are able to skinny out of or shimmy out of legal predicaments is by either not taking an oath or taking an invalid oath, when the time comes. And so we're going to talk about the importance of a bond uh, a little later on, and the importance of the oath, because if you don't have anything to reinforce or to enforce the fact, or enforce the people to do right, a lot of times they just won't. But we were not left powerless, and we are not just out here with no authority and no power. We actually have authority and power, but we have to know what it is, because you have to. We'll get into it, but there's a maxim that literally talks about this. So a matter must be expressed to be resolved. And this is the reason that we use written affidavits. Let us therefore come boldly unto the throne of grace, that we may obtain mercy and find grace to help in the time of need. And so if it's not written down, if it's just talked about without a sworn oath, then there's nothing to be held to. So we use the affidavits to perform in court, and to perform our contracts, and to uphold our rights. So let your moderation be known unto all men. The Lord is at hand. So this speaks to the your moderation be known to all men. So how is it going to be known for men who exist after your generation is not around anymore? It will have to be by the written word, and the result of that is the Lord is at hand. So that speaks to the authority of the written word. And it says in Ephesians, as for me, that utterance may be given to me, that I may open my mouth boldly to make known the mystery of the gospel. Another reference to why it's important to use writing to assert our rights. Now, you still have to be able to perform, in oral arguments, but the affidavit is powerful and it's enforceable. And the legal version of this maxim is, he who fails to assert his rights has none. And that is the reason that a matter must be expressed to be resolved. And the manner in which you express it will have a lot to do with whether you're able to resolve it or not. So he who does not deny admits. An unrebutted affidavit stands as truth in commerce, admiralty, lex mercatoria, and public policy. And this is really this speaks to the process of the courts. So the scripture says, "But the word of the Lord endureth forever, and this is the word by which the gospel has been preached unto you." For when God made promise to Adam, because he could swear by no greater, he sware by himself. So God took an oath on himself, and he said, "Surely, blessing I will bless thee, and multiplying I will multiply thee." And so after he had patiently endured, he obtained the promise. Abraham had endured and obtained the promise that God had swore an oath on himself to bless him and multiply him. And so the process of affidavits, you submit an affidavit, and well, we'll go over it in the next slide. An unrebutted affidavit is acted upon as the judgment in commerce, equity, admiralty, lex mercatoria, and public policy. For verily, men verily swear by the greater, and an oath for confirmation is to them an end of all strife. That speaks to the strength and the power of the oath. Wherein God, willing more abundantly to show unto the heirs of promise the immutability of his counsel, confirmed it with Abraham by an oath on himself, to show that he was, just as serious as he could be. And so this is not a scripture, but any proceeding in court, tribunal, or arbitration forum consists of a contest or a duel of commercial affidavits, where the points remaining unrebutted in the end stand as the truth and the matters to which the judgment of the law is applied. And this is another reason that you are entitled to face your accuser and to know the nature and the cause of the charges being brought against you, because you can see what those points are and you can prepare a defense and rebut each of the points. And once you do, if you successfully rebut each of those points, your rebuttal has to be rebutted to overcome it. So because an unrebutted affidavit stands as truth in commerce. So he who leaves the field of battle first and does not respond to the affidavit loses by default. And the entire book of Job is this, going back and forth with his friends, and they're making the case for the love and mercy and grace of God. And ultimately, Job won the case, and received back everything that he had lost. And then in Matthew it says, "You'll be hated by everyone because of me, but the one who stands firm to the end will be saved." And that's why we speak about making sure that you answer those affidavits and don't give up and don't get in your feelings, and try to come at every one of their accusations. Well, you can rise above the accusations when you understand jurisdiction and how to remove yourself from the contractual jurisdiction where they are masters of the field. And you can get into and this is where the authority that comes with the Holy Spirit, and this is the authority that comes with knowing who you are as a child of Yahweh and a living man or woman, comes into play, because you understand that you are in higher jurisdiction of the land and air. The legal maxim is, silence comprises agreement in commerce, equity, admiralty, lex mercatoria, and public policy, as he who does not deny when he has the opportunity admits the facts presented to him. And the legal version of this maxim is, he who does not repel a wrong when he can has occasioned it, or occasions it. So every time they send an affidavit, you have to, if people react the way that I do, then whenever you're accused of something, it tends to kind of take the wind out of your sails, and then you struggle with defending yourself, because you feel attacked. I've got a really strong trauma response when it comes to feeling attacked, and so there have been cases where I didn't rebut properly, and so I didn't prevail in court because I let my emotions override my common sense. And when I learned how to um, understand and walk in the jurisdiction that uh, that we have authority over, things changed for me as far as my performance in court, and hopefully it'll change for you as well. So, he who bears the burden ought also to derive the benefit, or he who gets the benefit has to carry the burden. And sacrifice is the measure of credibility, and one who is not damaged, put at risk, or willing to swear an oath on his commercial liability for the truth of his statements and the legitimacy of his actions has no basis to assert claims or charges and forfeits all credibility and right to claim authority. And I didn't put all the scriptures in here because the focus of this one is going to be one who is not damaged, put at risk, or willing to swear an oath on his commercial liability for the truth of his statements and legitimacy of his actions, has no basis to assert claims or charges, and forfeits all credibility and right to claim authority. The way that they overcome that, whenever a plaintiff comes against you and is filing all these accusations against you, is they're using the law of agency to have the prosecutor come and do the attacking. Well, he doesn't have any risk. He can say whatever he wants. He can make up stories. He can, anything that he can, prove or anything that he can, put a plant in the mind of the jury is blah, blah, blah. Well, the thing is that he's not completely without liability. And we're going to talk about in the next few slides how they actually do have to sacrifice to have the credibility to bring these charges against us, and we do have recourse against them. So, except for a jury, it is also a fatal offense for any person, even a judge, to impair or to expunge without a counter affidavit any affidavit or any commercial process based upon an affidavit. So, what that means is that without a judge nullifying your process, or a jury without a jury nullification, your private administrative process is valid. It also says it's against the law for a judge to summarily remove, dismiss, dissolve, or diminish a commercial lien. Only the lien claimant or a jury can dissolve a commercial lien. A lien or claim under commercial law can only be satisfied by one of the following actions: a rebuttal affidavit of truth supported by evidence point by point, payment, agreement of the parties, or resolution by a jury according to the rules of common law. And then it's supported in the Bible by Genesis 2:3. It says, and God blessed the seventh day and sanctified it, because that in that day he rested from all his work which Yahweh had created and made. Or there was an end to the issue. It was finished. He had done the work. He was fine. He was happy. He finalized it, and then he took a break and said, okay, here we are. And the legal maxim that is referenced to this is, if the plaintiff does not prove his case, the defendant is absolved. The plaintiff would be the other party, and the defendant is, of course, I'm putting myself always in the defendant position because that's where I've mostly been at, is in the defendant position. But let's go to the next slide. This is where it gets good. So the bonding of court officials, and this is why it's important, they can't function lawfully without a bond. If they are acting as a court official without a bond, they're breaking the law, and you could very easily have them arrested. All men have a remedy by the due course of law. That's actually a maxim. And it says, if a remedy did not exist or does not exist, or if the existing remedy has been subverted, then a man may create one and endow it with credibility by expressing it in an affidavit. So here we're talking about the private administrative process again. And another point of this is, a foreclosure by a summary judgment non-jury without a commercial bond is a violation of commercial law. A foreclosure by a summary judgment without a commercial bond is a violation of commercial law. And that is why, if they don't have a bond on record in their office when you're in court, they're not acting as a judge. An official must demonstrate that he or she is individually bonded in order to use a summary process. And this goes for process servers, this goes for the sheriff, this goes for the city police, this goes for the clerk of the court. An official who impairs, debauches, voids, or abridges an obligation of contract or the effect of a commercial lien without proper cause becomes a lien debtor, and his or her property becomes forfeited as a pledge to secure the lien. I'm not going to go giving you ideas, but I've seen some pretty interesting things happen when people have gone through the private administrative process, placed their commercial lien, and then foreclosed on that. So before we get to the private administrative process, we have to have the consent of the governed. So this is a term that is used in the Constitution, and it's a very important term because consent makes a law. And we're talking about the water jurisdiction here. You cannot have a valid contract without consent. Without consent, there can be no law. And this is referring to the body of rules that, or the body of actions that are the consequences of the law. Consent is an act of reason and deliberation. A person who possesses and exercises sufficient mental capacity to make an intelligent decision demonstrates consent by performing an act recommended by another. Consent assumes a physical power to act and a reflective, determined, and unencumbered exertion of these powers. So if you consent because someone's going to blow your head off if you don't, then you have not exercised a reflective, determined, and unencumbered exertion of these powers. If you are encumbered by threat of legal action or by duress or by intimidation or by fear of the consequences, especially the legal consequences, any contract that you enter into under threat, duress, or coercion is an invalid contract. And if you can prove that you were under duress when you signed, then you can get out of the contract. Theoretically, you may have to fight a little bit because I'll tell you, these guys do not give up easy. They if they're willing to pull a gun on you to get your consent, they're willing to do all kinds of stuff to keep it and continue to act under that fraudulent power. The basic elements required for a legally enforceable contract are mutual assent or consent without duress, threat, or coercion, and that's on both parties, or all parties to a contract must have consented. It is expressed by a valid offer and acceptance. So the offer has to have been made, and your acceptance of that offer has to have been demonstrated by either taking actions, performing an act recommended by another, or your signature, or you doing the thing that you agreed to by contract to do. Adequate consideration, a capacity to contract, and the legality of the agreement. So if the contract isn't to break the law or do something immoral, or actually to do something illegal, immoral, the legal system doesn't care about immoral. The law does, but so it has to be the legality of the agreement in the jurisdiction that the agreement falls under. So here's some more concepts that that are common, and they're maxims that are used in the law and the legal profession. So notice to agent is notice to principal. Notice to principal is notice to agent, and that is a maxim that is derived from the law of agency. An agent is one who is legally empowered to act on behalf of an entity or the principal. So when you send your notice to the sheriff's office, then if you put this disclaimer on there about the notice to agent and principal, then the principal and the agent have been put on notice. So that qualifies that step of the process. An agent is only liable if he signs in his personal capacity. If he does not denote agency, then he is responsible for the obligations of that contract. But when the agent signs in a representative capacity, he binds the principal and is absolved of liability. Now, to absolve yourself of liability, you have to literally sign in a representative capacity, or sign as the agent and denote who is the principal on the contract. So to have a valid claim without injury, there is no crime. So you have to claim or grievance which can be settled or resolved by way of legal action. A valid claim is not based on fraud, threat, duress, or coercion, which is fraud, and is not frivolous, which means it's not minimalist. It's not a trivial or insignificant. And first-hand evidence, and this is a maxim, first-hand evidence is always superior to third-party assertion. And so these are all important concepts to understand and things to know. And the more we study, the more we learn, the better your processes will be. And these are just some basic maxims and foundational knowledge for you to use. And I hope that everybody is keeping their nose in the books and sharing information that you find and having discussions with people, and don't take anybody's word for anything. Just because I know these things does not mean I know everything. So anything that I or anyone else says to you, find the root of it, find the book for it. There's the Black's Law dictionary for legal terms, and then there's also the Burton's Legal Thesaurus. You can Google any of these legal terms and find out what they actually mean, like the word of, the fact that it denotes an association to a thing, but not the thing. So the United States is not America. The United States is the United States in association with America. And the United States of America is not actually a thing if it's capitalized. So, and you know, these are the kind of ways that we get tripped up but when they use legalese on us. And so for us to move forward and to obtain our freedom, we're going to have to learn how to overcome these legal disabilities that are imposed upon us. And we have to learn what is and is not consent. We have to learn what is and is not a valid claim, because the last thing we want is people wasting their time on claims that are frivolous, or going to be thrown out as frivolous, or failure to state a claim upon which relief can be granted. So when you bring a claim and you know that the legal foundation supports this thing not to have happened, but you don't know what to ask for redress of it, they will literally throw your claim out, as valid as it is, because you didn't state a claim for which relief can be granted. So let's all work together and keep our nose in the books and keep going at it. And I have to give credit where credit is due. There are great things happening with Brandon Joe Williams and Kenyana Stone, Nefertari Toya, and Janiqua Miller. I want to name a whole bunch of other names. The people are moving and shaking and making things happen, and it's really exciting to see. And I'm studying along with everybody, and I hope that these videos are helping. If you want more content or different content, or if you want a presentation of a different topic, I'll study it until I can present it, and I'll do whatever I can, and maybe you should do one too. There's no reason we can't have more of these out there. So y'all have a great day, and thank you for watching this Smart Candy production.